Okay, I think we can start. Hello, everyone. My name is Fabiana. I am Legal Director at Drummond Advisors, and I will be presenting the webinar today with Loan. Before we start, please go to the Q&A or chat button whenever you want, and let me know if you are listening clearly. So we'll be sure that we are ready to go. Okay. Anyone? Everyone is hearing? Okay. So let's get started. I would like to advise you that we are streaming the webinar through Zoom, and we will also find this webinar on Drummond Advisors channel on YouTube. You will receive after the webinar a copy of the presentation by email, so you can have all the presented material in your hands. Loani, please introduce yourself.
Hi, everyone. How are you? So it's a pleasure to be here. This is, let's say, hot topic for now. It's H-1B season already. I know we can only file it in April, but we already have the pre-registration coming up soon in March, and it's very advisable to start now everything that you need to get ready for this process. It's very detail oriented, so please stay tuned to learn more about it. I am Loani Cesario. I'm the senior attorney here at Drummond Advisor for immigration cases. And I graduated in Brazil and in the United States, so I'm licensed in both countries to perform as an attorney. And specifically in the United States, I have the New York Bar, and I'm here to talk to you more about the H-1B process. Thank you.
Okay, let me change. Okay, here is the agenda of today's webinar. As you can see, we'll have frequently asked questions by the end of the presentation. So feel free to send your questions here on Q&A button. So I will try to address them during the presentation, but some of them will be addressed to Loani by the end of the presentation, okay? So I will let you with her. Loani, please.
All right, I'll take it from here. So as you can see, we have a lot to cover, but those are, I would say, very objective subjects, and we will make it in an hour, don't worry. So first topic is a summary of what the H-1B visa petition really is, what it entails, what the legislation speaks of, and what criteria should be covered. So first and foremost, it is a non-immigrant visa, which means you're expected to be in the United States on a temporary basis covering this position. However, it has what we call a dual intent. And what that means is you can basically change your mind whenever you are in the United States and you're using your right to be here. So you can change and decide to be an immigrant in the United States, what is more popularly called a green card. This helps a lot because whenever we talk about fraud prevention, having to wait 90 days to file petitions, whenever you actually come to the United States, all this is not applied to an H-1B petition because it has dual intent. And as I mentioned, you can change your mind, quote unquote, and decide to actually come in a permanent position and on a permanent basis. Sponsorship is required, which means a U.S. company has to be the petitioner, has to sponsor your visa. It is a petition for skilled professionals, which usually means you have to have a degree and experience related to the area of expertise. Specialty occupation means it has to be something that only that foreigner can do in a way. Okay. This is, we can make it simple here and just state that, but this has been the biggest discussion during the Trump administration because they have been changing what specialty occupation means without actually changing the current regulations. But a lot has happened. We are expecting a lighter approach from the Biden administration, and we have been seeing many approvals, and we have been seeing successful litigation on this matter. Okay. The visa is initially granted for up to 3 years, and when we say up to, it means it's up to the officer's discretion. 3 years is the customary time frame for at least the first period of the H-1B. It can be extended for another 3 years, and on special occasions, when you have an EB petition, a perm applied to you by your employer, you can add a year to that time frame. Okay. Well, derivative spouses, the H-4 cases, they usually cannot work. Okay, it's not directly a benefit that is granted to H-4 dependents. However, there are exceptions. So whenever the H-1B professional worker is already applying for an EB perm application, and it's already, let's say, on an adjustment of status, usually there are exceptions where the H-4 spouse can actually apply for an EAD. And we have been also seeing litigation where they have been successful in requesting that. It is very commonly known now that H-4s are actually as talented or even more talented than H-1B workers. So it is actually to the benefit of the US that most of the H-4 dependents can actually get an EAD and go to the market and share their talent. We can go to the next slide. Okay, so next subject to cover is H-1B cap and cap exempt petitions. So what's very special about the H-1Bs is that most people will actually have to apply for the caps, which means there is a limited amount of H-1Bs that will be granted each year. And these people have to actually be somehow selected, and we'll talk a little bit about how many H-1Bs are granted every fiscal year, and usually how this happens, how they're selected, and the cap exempt petitions. So H-1B visas are usually granted in a total of 85,000 every year. But they're divided in different categories. We always assume that H-1B cap cases, they're necessarily going through a lottery process. It has been true for the past, I don't know, decade, but that's not what the regulation actually states. It was supposed to be an exception. The lottery was not supposed to be what happens every fiscal year. However, because the H-1B is a very common type of visa, especially among students, among people who actually have OPTs or STEM courses, we have a very, very large amount of tech experts that are in the country that actually apply for H-1B petitions. So we usually have a lot more than 85,000 people applying for these H-1B cap petitions or positions. So we usually end up having to have a lottery process. We estimate an average of at least 250,000 petitions every year, give it or take. So that's why we end up always having a lottery. So the 85,000 is actually divided between 65,000 and 20. So the 65,000 is the average worker that has a specialty but has a bachelor's degree, usually from a foreign country. However, there's a very special portion of the caps that for these 20,000 that are actually people who have masters here in the United States. They can actually go through the process twice. They can run the lottery twice, so they have a little bit of a greater chance of getting selected. There are three main categories that are considered cap exempt. So we have spoken about the cap petitions, the people that will need to actually get an H-1B. And now these exceptions are for people who do not need to go through the lottery. So people who have a job offer in an institution of higher education, they will not need to wait for the pre-registration in March and then only file it on April 1st and so forth. Also, people with job offers in nonprofit organizations that are associated with an institution of higher education, they will not need to go through this process, and they do not need to be within the 65,000 caps or the 20,000. And finally, people with job offers from governmental research centers. So it's very focused on academic, maybe research for professors, very specific areas. So next, please. Premium processing fee. It is optional, but very recommended. And we will talk a little bit about this because in H-1B cases, this is very interesting how it actually is a benefit for H-1B petitions. For the I-129 form, where is actually the form where you petition to USCIS for the H-1B. But because of the high demand, because of the large amount of petitions that are filed all at once, right, and on specific dates, USCIS in most fiscal years, they actually suspend the option of filing with a premium processing fee, at least for a period. So let me explain a little bit better what a premium processing fee actually is and how this applies to H-1B cases. So the premium processing fee is a sort of customer service fee for USCIS petitions where you pay now $2,500 and your petition will be reviewed in 15 business days. So that's a great benefit because if you don't pay that fee, you might get your response within 5, 6, even 7 months. So it is to your advantage that you pay that fee because it is guaranteed that they will give you a response within 15 days. Otherwise, they will have to refund the full amount. That means that many officers will have a pile of cases there, and sometimes they issue template RFEs just because they don't want to miss the deadline. But comments on the side, it is usually recommended. So choosing to pay for a premium processing fee will reduce your processing time, but will not grant you any other benefits. So it's not like you're going to be on top of the line. It's not like you're guaranteed to be selected. It's literally just to have a faster decision, to really know if you're approved or if further evidence is required from you or if your case is denied. It is very important to mention that because H-1Bs are selected through caps and because the selection is for a specific fiscal year, your start date will be October 1st of the next year. So right now we're starting the caps for fiscal year 2022. Right? Meaning October 1st is already fiscal year 2022, at least for USCIS. Okay, it might be a little bit confusing, but that's how it works. Don't worry. So once again, H-1B petitions are usually premium processing fees are usually available for H-1B petitions. However, we do expect that it will be temporarily suspended, but don't worry, if it is suspended for this fiscal year, at some point they will resume it and you can file it at any time. So next slide, please. All right, so we have been seeing recent changes to the H-1B process. We are actually very happy with the changes. Last year, we had many H-1B cases that were successful, even without an RFE. We love to see that once they actually made a system that can detect fraud, we saw that a lot of people were discouraged to actually do what they usually did, to file tons of petitions for the same company or the same beneficiary. So it was, in at least in our experience, a much fairer process. Like, it was a fair process. And what was very good is that every year what we would see is they had the 65,000 selected, then the 20,000 selected, and then they sent the whole packet, and some were denied, right? Some didn't move forward. And all those caps were actually lost. And people that were actually entitled and people that were actually special workers, and they met the criteria for a specialty occupation, they did not have the opportunity to get that cap that was just lost in that fiscal year. And with a new process, what we saw is they were able to put that back in the lottery and select new people to actually get a chance to use the remainder of those caps for the fiscal year of 2021. So let me go through the changes real quick. So historically, employers, they would file H-1B subject petitions directly with USCIS, which means it was April 1st, it was a race to simply send out complete packages to USCIS. A lot of those would remain unopened because they would go through the process, they weren't selected, so USCIS would simply not even look at them. What happens now is there's a pre-registration process. There's a very small fee of $10. There's a new completely online system where you input some information of the employer, of the employee that is going to be participating in the maybe lottery. We know that most likely the lottery will happen, but this is a pre-registration process for the H-1B cases. So if they do not exceed a certain number of applications, the lottery is not necessary, as I previously explained. So with the pre-registration process, what happens is on March 1st, you can input that in the system, all the information, and show USCIS that you want to participate in the selection process. And by March 20th, give it or take, the selection process will have happened and the selection notices will be electronically sent to the attorney and to the petitioning company, which means whenever you prepare your packet, and if you're ready on April 1st or not, you have until June to actually prepare your packet, do your labor certification, do everything that is that it takes for a complete H-1B packet, and then send it to USCIS, meaning you know your case is going to be reviewed. You're not just going to be spending a lot of FedEx money, sending it out, and not knowing whether you'll be selected or not. So what we see as advantage is the process is faster. It has reduced wait times for CAP selection notifications because it's all electronic. Employers and sponsors are not required to file an H-1B LCA with DOL before they even know if their beneficiary is going to be selected or not. I mean, you can do it. You can be prepared to file it on April 1st if you really believe in your heart that you will be selected, but you don't have to anymore. Reduction of the overall cost. Of course, it reduced the cost both ways to USCIS because they had to send out really big packages back to you. And now they don't have to do that anymore. And for petitioners, because they avoid unnecessary legal fees if the case was not selected. They avoid costs with printing, with attorneys even, and well, with the overall process. It's a lot more beneficial to both sides. The process will prevent fraud and multiple applications for the same beneficiary by the same employer. Why is that? Because you have a pre-registration process. So you have to inform who you are, your EIN, you have to inform who you're applying for. So the system will not accept more applications for the same person. So this is great for everyone. It's a fair process. And let's see, so there's preference and priority to high skilled and highly paid workers. Well, that is true because, as we mentioned, people with masters here in the United States, they actually get 2 shots. But that doesn't necessarily mean that people without that will not be selected. Okay, we had several cases for this year that were selected and they did not have masters. All right, so we're finally on the timeline for the H-1B process. I think this will make everything clearer to you how this new process actually works, right? In real life, in real time. We're going to talk here about why we consider that the H-1B season has already started and that we have to get moving, we have to get going if H-1B is what you want. So we always recommend that in early December, you make an assessment, like you company, you beneficiary, because you have to start discussing your strategy with your immigration attorney. It is very important to understand what is your specialty occupation really. So how is your position classified before the DOL? What's the salary that DOL actually requires to be paid for this position? What are the requirements in terms of job postings? And the LCA, what does it mean? What's there? What's in it? What am I going to be signing as an employer? Then in early January is already time to start gathering transcripts, for instance. So if you graduated abroad, if you're a foreign worker, you will really need to show the US government that you have an equivalency of your degree in the United States. Early February is already time to start gathering all the supporting evidence for your pre-registration. Remember, March 1st, it will open, so you got to be ready. Now, finally, March 1st through March 20th, you can submit your pre-registration along with the $10 registration fee. We always recommend that you do it first thing. So it's March 1st. We recommend you're ready to file it on March 1st. if you are ready, if you are organized, and you are prepared, it's possible to actually do it in few minutes. In all the cases last year that we were all prepared, that all the questionnaires were filled out and filed with us, and clients were always available on the phone to actually authorize and well, we'll further guide you, obviously, but it was a process that took minutes. So being ready is crucial. Okay. Finally, March 31st, you will already have the results for your lottery, meaning if you were selected, you have a selection notice already, and you have to be to start your H-1B case, your dossier. Another interesting data is if you were not selected, you're not going to be shown as not selected. You're going to be there in the system waiting, because remember I mentioned that if some of these caps are not used, they're going to select people again, and that's where they're going to get that those people from the same system. Please, let's go to the next one. Okay, so continuing, April 1st is usually when they allow H-1B petitions to be sent directly to USCIS. So if in January, February, you actually prepared your LCA and prepared your case, most likely if you were selected in March, you will be ready on the first week of April to actually file your case, send it out to USCIS. If not, that's not a problem, because in the selection notice, they will tell you until when you can file your case. So usually somewhere in June, probably June 15th, which is what happened last year, you will be able to file your H-1B petition. There are many steps to take, and there's a lot of strategy involved. So the attorney, the beneficiary, and the company will have to determine what the prevailing wage is, meaning what's the minimum salary and benefits I have to pay for that specific position. We will need to develop a detailed job description that will reflect what the day-to-day of this professional worker will look like. What's the specialty occupation going to look like? And usually what we do is we get those duties, and we get everything that this person has actually studied, and we try to link and show that the person not only studied it, but they will be applying this on their day-to-day. We gather supporting evidence. We file the labor certification before the Department of Labor. They're usually very, very ready for the H-1B season. So they usually take a week or less to actually certify the labor certification. And also we have a lot of work because we have to prepare the H-1B forms, a support letter, and everything related to the job description, prevailing wage, and so forth, and a little bit about the company and what the company's industry really is. So from April 15th through June 25th, your petition should be sent to USCIS and must be delivered before June 30th, because after that, they will no longer accept the petition. So between July and September, they will be adjudicating the petitions. Hopefully by then the premium processing fee is back, right? Because it usually gets suspended, and then around May or June, they resume it. That's when they will start saying if your case was approved, if they need further evidence, and so forth. This is only the merits portion, so that's why we mention here that the consular portion of your case must start being prepared in case you need to travel. Okay, if you do a change of status in the United States, you can actually stay here because your approval notice will come with a new I-94 already placing you on an H-1B status. On October 1st, which is actually the new fiscal year, right? Because right now we're going to be working on the fiscal year 2022. So on October 1st, for USCIS, we will be on 2022, right? Technically. So October 1st is when you're actually allowed to start working under an H-1B status in the United States for your employer, for your petitioner. So it is possible to prepare your petition, and if you are selected, you may have it already filed. That's what I mentioned. That's when I mentioned you can start today to prepare your petition, and if you're selected, you can take advantage of the fact that they will open. They'll be open for filing on April 1st. Important. A new lottery takes place before September in case your H-1B caps for the fiscal year are, in case caps are still available. So they will make a new selection. Perfect. So next, please. Okay, there we go. H-1B filing fees, that's a very important portion. It's not always straightforward because it depends on the company's size and how many H-1B or L workers the company actually depends upon. That's the term the government actually uses. So what are the costs? To participate in the pre-registration step, it's a very low cost, as I mentioned previously. It's only $10. It's for each registration submitted, so it's not one for the company. All right. Phase 2. So let's assume you were selected. What will be the costs? So the base filing fee is $460, meaning the I-129 petition per se, which is the request for an H-1B petition. Since this is your first H-1B, because you're participating in the lottery, you will have a fraud prevention fee. What is that? It's a $500, I would call it penalty fee to show that this is a real job offer. Believe it or not, in the past, it was very common for companies to actually file for workers that they never actually intended to hire. Sometimes for family members, sometimes for friends. And USCIS many years ago decided to actually charge this anti-fraud fee in a sense of good faith from the company. Okay. ACWIA fees are actually directed to US workers. The whole idea of this fee is that, well, today you petitioner, you US company need a foreigner because they have specialized knowledge that US workers do not have. So please help US workers to gain that type of knowledge, gain that type of specialty. So contribute to our funding to create courses, create training programs for US workers so that in the future, you will not depend on H-1B workers. Okay, so if the company has less than 25 employees, they will contribute with $750. If a company is larger than that and has more than 25 employees, that will be a $1,500 fee. Public Law 114-113 is a penalty, I want to say, for companies that they they consider to be H-1B dependent companies with more than 50 employees with H-1B status. The premium processing fee is there, although it's an optional fee. It's very important to mention because we usually encourage people to use it to benefit from it if possible, if not suspended in that fiscal year. And it's a $2,500 fee. So unfortunately, COVID is still out there. We still have a lot of changes that occurred specifically because of this pandemic. Vaccines are out there. The US started the vaccinations this December, but we're still in a process, right? So as of now, we are still facing the pandemic. We are still facing a lot of these effects on our day-to-day. And let's mention a few. So, well, presidential proclamation was extended. So, well, excuse me, we say March 13th, but it's actually March 31st. We will still have the H-1B visas suspended. Will that directly impact everyone? Not exactly. So if you are in the United States and you made a change of status and you have your I-94 stating you are an H-1B worker, you do not need to actually rush to the consulate and get your H-1B stamped. But if you do need to do that, unfortunately, you won't be able to right now. First, because a lot of countries are already closed. Second, because US embassies and consulates are mostly closed around the world. So let me take that back. They're still working, but they have stopped to actually get interviews done. They don't want the regular public. They see hundreds of people every day, so that's not possible during a pandemic. So they're only taking what they call national interest exemption cases. However, H-1Bs are suspended. So even if they were to open, even if everything went back to normal right now, because of the presidential proclamation, H-1B visas are suspended. So they could not be stamped, only if an exemption applies. Good news is Inauguration Day is coming up. The 20th is almost here. And Biden has already stated that at least for 60 days, all the midnight regulations that were signed by President Trump as of now or as of recently, at least for 60 days, they will all be suspended. So Biden's team can study these measures and see what actually makes sense, what actually applies. And we might have news soon. Okay. April 22nd, Presidential Proclamation 10014 actually suspended the entry of immigrants. June 22nd, the Presidential Proclamation was extended and actually included non-immigrant visas. December 31st was supposed to be the end of these restrictions and suspensions. However, it was extended, as explained before, until March 31st. So it's nonstop, right? We are always getting news. So as of today, we are expected to see a new regulation for H-1B cases. Will that actually work? Will that actually be effective? First of all, not as of now. The regulation actually foresees a 60-day period to actually become effective. And on top of that, because AILA, which is the Association of Immigration Attorneys, and a lot of other associations are not very happy with the text. We know that litigation will happen, and we know that Biden's administration is a lot more immigrant friendly, if I can say so. So maybe this won't even come into effect, but we are expected to see this new wage-based selection process, at least the text, and what DOL intends to implement in the near future. So they want to change the lottery all over again. We do have an advanced copy from USCIS, which they are now considering a final rule. But believe it or not, this has been happening for the past few months. In December, they actually filed what they back then called a final rule that was not approved. Public comments were massive and they had to withdraw. So I do not want to overwhelm you with this. Basically, what they want is to actually get higher salary people to be a priority in the selection process, just in a very, very general perspective. Okay, but this is something that looks a lot more like the Trump administration, where they were only focusing on highly skilled, very well-paid workers. The public charge rule was there to actually say we only want the rich in the United States, but Biden has already stated that he will remove the public charge rule. So I don't think that this type of ruling will stand in a world where the public charge rule is eliminated. Okay, so what else do we have? All right, we got to the frequently asked questions. We have prepared some, but we also want to hear from you what your main concerns are, what your questions are, and we're here to help.
I think we can start with the ones that we pulled out, okay? And we have some here. Most of them are already addressed. And there is another one here that I will ask you after you go through the questions that we have already prepared as frequently.
Okay, makes sense. Let's go over the ones that we already prepared, and let's hear from the public.
Okay, I will ask you the question, and then you can answer to us. Okay. So the first one
All
is,
right, no problem.
Okay, what is the difference between a change of status cap petition and a consular processing cap petition?
All right, so to make it simple, the main difference is if you are already in the United States, if you do a change of status, let's say from an OPT, from an F student visa, from even a B status, and you change it to an H-1B petition, and you are approved, that means you're allowed to stay in the country for as long as this petition is being adjudicated. And once you are approved, when you get your approval notice, you will get an I-94 already stating that you are under an H-1B status. So you can go ahead and, for instance, request your social security number. And in October, you can actually be part of the payroll of that company. If you are in a consular process, you actually need to get your original approval notice, go to the consulate, get your interview done, get your visa stamped, And then when you're near your start date, you can come to the United States.
Okay.
Sorry, just one comment.
Sure.
It is very important to mention that OPT students, they actually have a very special treatment. There is a cap regulation specifically for them. Okay.
Okay. The second one, assuming my registration is selected in the lottery and an H-1B petition is filed for me, will I have to leave the country and or stop working if my OPT expires after April 1st, but before the October 1st, 2021 start date?
All right. So because there's a special regulation just for OPT students, it actually really depends if you were in the grace period once you actually filed with USCIS. So for those people, I strongly recommend you prepare your packet right away. And if you're selected in March, you file it right in the first week of April. Because if you do that before you start your grace period, you can continue to work. If not, we would have to evaluate on a case-by-case basis, because even a 1 day difference matters, but usually you have a coverage, you have a very special treatment when you are under an OPT status.
Okay. If I am rejected in the lottery and my OPT is expiring, what are my options to continue working in the USA?
Well, the easiest one is if you are part of a STEM course or STEM category, you can always file for a STEM extension. But if that's not your case, I would say please come talk to us, and we would have to actually review your resume, understand if you have a sponsor, and we have to go from there. Like we have to understand if you have a sponsor, for how long do you want to be in the United States, if you have any special, let's say, extraordinary abilities, if maybe you are dating a US citizen. We don't know. So we want to help you.
Okay. Can I leave the country after the H-1B petition is approved, but before October 1st?
I mean, you can leave the country. It's so difficult in this crisis to say, hey, go and travel, because we don't know what tomorrow brings. We never know if the borders are going to be closed, if this is going to get better, if it's going to get worse, if the consulates actually will open again for the public. So if this were a normal world, I would say yes. And then you go, you schedule your interview, you stamp your visa, and a little bit before, about 30 days before your start date, you can come in. But it's a COVID-19 world still, so difficult to say.
Okay. The last one I have here from the ones that we pull out, then I will check the Q&A. If my H-1B cap petition is approved, will I need to apply for an H-1B visa at US Embassy or Consulate abroad?
Well, okay. So usually if it's a non-immigrant visa, it necessarily entails the merits and the consular interview and the visa stamp. However, if you are in the United States, if you're not leaving the United States anytime soon, and if you were approved with a change of status and you have received a new I-94 with your approval notice stating that you are under an H-1B status, you're not obligated to travel and stamp your visa. I mean, you can wait until you actually need to leave the country and do it.
Okay, so I will address 3 questions that we have here on Q&A. The first one is
Perfect.
what documents are required to be submitted by March on the company side and on the beneficiary side. So for the pre-registration.
All right, for the pre-registration, no documentation is actually required, just the fee. What we do need to come forth with or to file is information. So company information like address, like who is the point of contact, who is legally responsible for the company. And for the employee, if we have their passport, like the bio page of their passport, we can already respond to most of the questions. Of course, it requires a little bit of knowledge on the system and the pre-registration format. However, the amount of information we need, we send out a little questionnaire to the company and the beneficiary, and that suffices.
Okay. The second one is
sorry. Let me just include one little thing, one little detail. As I mentioned previously, we usually need to let the company know that we're going to be filing the pre-registration because they have to authorize certain things that we file. So it's usually important for them to be ready to answer our call and to go to the system and authorize.
Okay. Could one apply for the H-1B and another visa at the same time?
Well, that is a good question. Does it make sense with exactly what you're telling USCIS about you, about your career, about who you are, and about the company that will be sponsoring you, for instance? Is it possible? Yes. Is it prohibited? No. But does it make sense? Does your story connect? Or are you stating something in one petition and something completely different in the other petition? So that's something you really need an immigration attorney to evaluate with you.
Okay, and the last one is just to check if the wage changes that are maybe up to come, if they will affect the lottery this year. Probably not, right?
I am so sorry. My internet went off for a little bit. I did not hear your question. I'm sorry.
I will repeat. Okay, no problem. It's just to check if the new regulation that you mentioned regarding the wage tier they are intending to apply, if you believe it's gonna be applied for this lottery this year.
All right. So they are trying to enforce it as soon as possible. They are trying to make it published today and in 60 days become effective. However, let me give you an example. This H-1B process that we're seeing right now that actually happened last year, and we were able to file petition in this format, it was actually approved in the very previous fiscal year. And when they actually faced the whole situation, they realized the amount of people that were applying and the amount of work that it took to actually put in place a system that took all that information and was actually secure, safe to be used. They said, hey, wait a minute, I'm sorry. Wait, let's put that on hold. Let every attorney actually study the rules. Let us study this carefully. Let us do tests. So I think that even if they succeed in publishing this today and making it effective, they will say, all right, this is what's going to look like, and we will implement this as soon as possible.
Great. Okay. There is no other question. So I would like to thank you, Loani, for all the information that you provide to us today. And thank you all for the participation. Here are our contact information. If you have any other questions or if you need any support for your application, please send us an email for us. And okay, that's it. Luana, do you want to say goodbye?
Yes. So thanks everyone for joining us. I really hope it was helpful and useful. And I really want to make myself available to any remaining questions and anything that I can further assist you with. Thank you, thank you, thank you.